Commissioner Thompson, thanks for being with us. A few folks are still just joining after lunch, but excited to be meeting today and glad to see everybody. Thank you. Good afternoon, everybody. It's 1:01. It's July 18th, and we're here to talk about Goal 5 cultural areas again. It is our third rulemaking advisory committee meeting of sort of this phase. Really grateful for folks making the time. It's a summer afternoon. There's a lot of places you could be, but thank you for being here. Um, I'm Kirsten Green. I'm the Deputy Director at the Department of Land Conservation and Development, and I have the honor and responsibility of serving as our agency's tribal liaison at the delegation of our Director, Bateman. Commissioner Leanne Thompson, Clatsop County Commissioner, is our LC Land Conservation and Development Commission liaison to this work. So Commissioner Thompson, would you be willing to give us a welcome? Thank you.
I am. Thank you for that honor. I'm the Coastal Commissioner on the Land Conservation and Development Commission, as well as a Clatsop County Commissioner. So I have a dual focus. I also live between the marine reserves and the state forest. So I bring the perspective of someone who is not an urban service level environmentalist, but someone who lives where nature can kill me if it happens that way. It's with the greatest respect and affection that I welcome you here today to do this work as we have the focus of including everyone and engaging in work that has not been done before, at least not the way we intend doing it, which is to take everybody into account and to find common values and common ways forward. So thank you so much for being here and for bringing your intelligence and your grace with you today.
Commissioner, thank you. And I do want to welcome Hania Miller attending in the place of Councilmember Anderson for the Klamath Tribes today. We have a time for kind of public comment here in a little bit, so there might be some folks who want to raise their hand their virtual hand at that time. Just to in the interest of saving time, we won't do a full round of introductions, but Jess, if you could move to agenda review, I'd be grateful. And yeah, if RAC members, if you don't mind renaming yourself with RAC at the end, that would be great. So here's a little welcome, a little reminder. Some beautiful cedars. So to rename yourself as your first and last name, and if in RAC to indicate you're a Rulemaking Advisory Committee member. If Rulemaking Advisory Committee members are comfortable and can keep your cameras on during the meeting, that would be awesome. But I know that a lot's going on. Folks have kids at home over the summer, so we understand if you can't do that, or if you just need a break and to get a snack or anything during the meeting, please be comfortable. So are there any, as the agenda, Jess has there on the agenda. We want to talk about a few things today. You probably saw this in your packet. So we want to talk about whether or not RAC members recommend a timeline for decision on legislative amendments to bring a cultural area for consideration to a local government in Oregon. That's kind of diving deep in the weeds on something we were talking about last time. And then also we want to look at the full draft rule and the impact statements, the fiscal and housing impact statements. It's a requirement of state law that rulemaking advisory committee members, if we have a RAC, look at those impact statements and provide comments. So those have been in your packet. I know folks want to discuss them today. We include the racial impact statement as well for RAC review. So feel free to comment on that as well. It's not a requirement that RAC members comment on that, but I know that folks have thoughts, so we look forward to hearing those. And then, of course, the full draft rule, if I didn't say that already. We have received a letter from the Confederate Tribes of Warm Springs of Oregon, and I see that Mr. Squimphin and also Ms. Grover from the Confederate Tribes of Warm Springs are both here, so we'll be able to provide put some voice to that if they wish, as we discussed today. Is there any questions about the agenda today, and then kind of where we go from here? I could mention maybe a little bit of where we go from here. So this is July. We hope to finish our work kind of with your initial guidance, and I want to put an emphasis on initial because it's never over till it's over. But your initial guidance here, we will go a little bit dark in August to prepare the final rule for our legal counsel review and then posting to the Secretary of State's notice for the official comment period starting on September 1st. Currently, that's scheduled to go through October 5th. Our director has said that it's okay if we take this item for adoption, not at the October LCDC meeting, but in the December. So if we do extend that public comment period, we'll be sure to let everybody know. But currently, consultation and public comment would need to wrap up by October 5th. And we might revisit that at the end of the day today and say, yeah, the topics that are raised, we want to extend a little bit more. So we'll just revisit that. But currently, close of public comment is and consultation would be October 5th, and then the final hearing would be October. At the end of October in front of LCDC, and then we would work on implementation and guidance and have the rule go into effect June 30th, 2026. So that's what we've been working towards. It's been a long journey. Again, thanks for being with us. Any questions or comments about the kind of what we're doing today, the next steps? Awesome. Thank you. Okay. All right. Are there any community members with us today that aren't RAC members that would like to make a public comment? We have disabled shared screen for everybody, so we shouldn't have the disruptions last time, but if you'd like to say something, please raise your hand. Okay, I don't see any, which picks up a little time, which is great. Jess, thank you. I think we can actually um go forth into the next slide, which is exciting. We're getting really into the meat of it again. So we sort of just dove in here, and if you have your packets near you, I would like to draw your attention to where this piece that we're asking a question about lives in rule. So this is what we've been talking about in 4C. So we've been spending a lot of time with 4C, and for good reasons. It's new in it would be new in the state of Oregon. So it'd be the local government accepting applications to determine if a cultural landscape feature is significant and to complete the Goal 5 process for it. The local government shall process the application as an amendment. We have said that depending on whether or not it's one property or multiple properties, it would be the local government would decide whether that should be correctly processed as a quasi judicial application or a legislative amendment. In Oregon, quasi judicial amendments have to be decided sort of start and finish in 120 days for cities and 150 days for counties. Um, and that we know that's incompatible with consultation and Confederate Tribes of Warm Springs. Mr. Austin Smith Jr. also with us today. His letter was clear on that. Um, However, we're kind of stuck with it right now under sort of court findings and judicial practice. So if it were legislative, however, there's no timeline at all. And the question sort of to members is, um, should we establish a timeline? We had talked at our last meeting about maybe 2 years, and the applicant could extend that, whether it be a tribal applicant or another Oregon-based government. Um, so that's the question. Nick, I see your hand, which is great. I did kind of skip over when I was reading there on 4C. It's on page 4 of the rule in your packet. We, based on discussions at our last meeting and also guidance from Legislative Commission on Indian Services, reminds us that we're executive branch, and Patrick and Alyssa weren't able to be here today, but we have narrowed it right now to be an Oregon-based government, which would unfortunately for this pathway exclude terminated tribes in Oregon, which is not our true desire, but trying to work within the confines of law, and also tribal governments outside of Oregon. They, terminated tribes, culturally identified groups, tribes in other states would always today and in the future be able to appeal to the local government to bring that application forward directly. So it doesn't cut off all pathways, but it clarifies this pathway for Oregon tribes. So that's in 4C too, or 4C as well. So, Nick, we want to start us off in the conversation, please.
Well, yeah, I just would like some clarity about the timeline issue because you just stated that there's a timeline for quasi judicial, but it has been stated in this meeting, and the rule says it shall be processed as an amendment to a comprehensive plan. And I just want to make sure we're on firm ground. I thought it has been stated that amendments to comprehensive plans are not subject to the 150, 180-day rule. So I'd really want the group to be on the same page on this
Mhm.
because I've heard it both ways, and I don't just want to make sure.
Sure. Thank you. And I think that was some of Mr. Ed Sullivan's also not available to be here today. He also put a comment in the record. But Gordon, if you could clarify that for us, if there's any wiggle on quasi judicial, if it were an amendment to a comp plan, if it's, go ahead.
Thank you. Gordon Howard, Community Services Division Manager. I did see Nick that Ed's comment to that effect, and I have never understood that any quasi judicial action was not subject to the 120 or 150-day rule. We will look into that, but the idea, though, I think one thought is that. Maybe Ed is thinking, and I'll have to look at this, that a comprehensive plan amendment is never quasi-judicial. And that is not necessarily the case. A quasi-judicial versus legislative distinction is not based on at all on the type of application. It's based upon those three factors in the Supreme Court decision, Strawberry Four-Wheelers versus Benton County. And we'll look into that further. But I think the idea is that it's a very remote possibility that an application like this would be a quasi judicial application as opposed to a legislative, but very remote is versus non-existent is the question, and we'll look into that further.
Nick, thank you. Appreciate that. Ms. McDonald, Katie, please.
Thank you. I just, for the comment about the tribes and the who would be able to bring forward an application recently through a separate project and process that Metro's been engaging on and some conversations we've been having with ODOT. I just wanted to flag that their tribal consultation plan that was recently updated in 2024 has two tables, one of which is a list of state of Oregon federally recognized tribal governments, and the second of which is a list of tribal governments with historical interests or ancestral lands in Oregon. And I'm just wondering if is that a place there or a resource, or how do we reconcile some of these places where there are conflicting or contradictory practices at the state level about
Mhm.
how tribes participate, including tribes who are present outside of Oregon. And I think we have heard informally that the Tribal Consultation Task Force that Shana Radford is working on may also be making some progress on this issue. So I guess my question to your team, Kirsten, is if the Tribal Consultation Task Force develops some type of new guidance that becomes the state policy about tribes based in Oregon versus outside of Oregon, does this rule get revised so that that can be changed appropriately if a change in that existing policy occurs?
Thanks, Katie. Great questions. And I believe Director Radford has joined us, which is great. So I don't want to put her on the spot, but Director Radford, thank you for joining us to just sort of hear this conversation today. I know there's a lot of discussion on this topic and a lot of different venues. Katie, I missed the table. Was it Metro or is it another state agency that has that table?
It is ODOT in
ODOT.
their 2024 updated tribal consultation policy
Ah,
for statewide transportation improvement planning.
great. Thank you. To your to your kind of that's fair point. The to your question about Director Radford's and the State of Oregon's Tribal Consultation Task Force, I can't speak for our director or commission, but that would be, it is normal for us to update rules when circumstances change. So I think that would be, this has been a priority of our director and our commission for some years now. And so it's not just a fly by night, quick one and done rulemaking. We're here for this is obviously a long-term process and will continue to be. So I would expect that we would want to conform our rules to evolving guidance from the governor's office on this matter. So I don't know, Director Radford, do you want to say anything here at this juncture before we go on to our next RAC members with their hands raised? That's a really putting you on the spot. I'm not even sure if you can come off mute.
I think I can. Can you hear me?
You are. Yeah.
Oh, okay. Hi, Katie. I don't think I can see you on the screen. Hi, everyone. So that's correct. That what Katie was talking about, we are right now informally talking with all of the tribal governments, and they're talking internally. So, but happy to be here. Obviously, can be a resource for any other questions, but I'm just here to listen in. So, thank you.
Awesome. Thank you. So Katie, yes, again, we would sort of revert. We follow that very closely. And I'll take a look at the ODOT's 2024 guidance. So we're aware, we can talk to LCIS about that too, about notice. So just proceeding carefully here with probably our first step would be for this rulemaking would be to clarify the pathway for Oregon tribes, not to the complete exclusion of other culturally identified groups, but just to create a clear pathway at this first juncture for Oregon-based tribes. It's not perfect. We know that the system on which we're building is not perfect at all, filled with a lot of trauma and historical wrongs. So just proceeding knowing that and seeing if there's progress to be made, let's make it. But we don't want to do more harm than good. So really careful about all that. So Katie, thank you for raising those good questions. Ms. Rolfe, please, Jill.
So it's been a little while since I read the Strawberry Hill case, but my understanding in the Strawberry Hill case was that was a zone change that was adopted as part of their ordinance and not their comprehensive plan. So I think that you need to look at the difference between the comprehensive plan and the ordinance changes. We were always informed by land use attorneys, if you have to amend your comprehensive plan, granted, the comprehensive plan is supposed to be more broad and not related to one piece of property. So I know that's a little different, but it's not subject to timelines. It's not quasi judicial. It's legislative. And so the main thing we were always asked is if your inventory that you're amending as part of your comprehensive plan, whether it's a map inventory or whether it's a list or whatever it is that identifies it, then that's not subject to the 120-day, 150-day timeline.
Thank you. We'll definitely check on that. We first had it as legislative because that was our feeling, but as some members of the RAC here brought up, like, hey, if it's one property, you're in a different zone. So we need, you're in a different situation. So we needed to kind of look at, are there cases where it could have been quasi judicial? But we also agree that this topic, these issues feel and seem legislative. It would just be those few cases where it would be limited to like a property owner, which could be rare, but it could be. So we'll continue to look at all of that. Jill, thank you.
So I guess my only concern is if we try to somehow bring in a time limit for just this, that it gets a little, I don't know, crazy when you start thinking about it, because they're going to start putting time limits on other types of inventories that we go through and we add. So that would be my only caution. I don't know that that would really happen, but I just fear if you open that door, you might actually receive some objections to that.
So thank you. Good to be mindful of the precedent we'd be setting. Yeah, thank you. Thank you. Ms. Miller, please, Carrie.
Thanks. I'm back to the definition of Indian tribes. And so when reading this, I just want to bring up, I think it's a little bit confusing where we have now struck, except where the definition of ORS 97740 applies, because higher up in number 1, we talk about archaeological sites as burials. And so when you go to 97740 and it's talking about burials and the tribes that you need to contact, it talks about those tribe of Indians recognized by the Secretary of Interior who have cultural lands in the state of Oregon. So if we're still referencing that and there's burials, say in cultural areas, I think there needs to be some guidance because you may be needing to contact other tribes, not just the 9 tribes of Oregon. So I'm not sure. I'm just raising this when trying to understand where this is going and how all the different state laws interact. I was just noticing that there's some challenges here with that. So how we're going to deal with that either in guidance or what the approach will be, but how we can solve that.
Thank you. Thank you. Thank you. Carrie. So Gordon, we can raise this for Steve, our DOJ. It's just to make sure that obviously we're not changing that state law, but how to clarify it perhaps in rule and certainly in guidance here that we don't have the authority nor the intent to modify that statute in any way in that notification process. Thank you. Gordon and Amanda, I'm sorry you're in a room together. Amanda cannot get at her computer today, so they're sitting unusually very close in a cube. Hello, I know they've been working together a long time. But Gordon, did you have anything to respond to before we turn to Ms. Adams or Shauna?
Yeah, there is an answer to Jill. Jill. There is a 1994 Luba decision that specifically found a comprehensive plan map amendment on a single property was a quasi judicial decision. I think the next question, though, was that, as I think Ed was asserting, that even if it was a quasi judicial decision, it wasn't subject to the 150-day notice period, and we'll look into that some more.
Interesting.
Do you know that case?
I just had it up from 1994 from Luba. I've got off that page. Yes, I'll look for it. It's someone versus the city of Eugene.
Eugene.
Yeah,
Okay.
1994.
Thank you. Dave may have our answer on that, but let me go to Ms. Adams. To Shauna, please. You've had your hand up, and then to Mr. Honeycutt, please.
I could defer to Mr. Honeycutt first.
Okay.
I imagine he's going to address the same thing and maybe better. If not, I'll.
Thank you. Dave, were you going to jump in on this point or a broader point? Yeah.
Just to say that anytime you're amending the comp plan, the 120, 150-day rules do not apply. That's set out specifically in the statute. So if it requires a comp plan amendment, then the statutory timelines don't apply.
Okay. Dave, thank you. Interesting. Very interesting. Which goes back to Katie's point actually at our last RAC meeting. And Katie raised, is 120 days and 150 days really sufficient for meeting consultation? We know it's not. So if we can altogether sidestep this with comp plan amendments, that would be interesting, and have time for more meaningful consideration. Dave, thank you. We'll continue to look at this, folks, and get back to everyone here, and also kind of post it in a way that folks who aren't on the Rulemaking Advisory Committee could also be apprised of that, anything we find. Please, Shauna, thanks for waiting.
Oh, that's good. Mr. Honeycutt did say what our understanding is in Lane County, we process most of our plan amendment zone changes as quasi judicial matters and consider them not subject to the 150-day rule. And even if they were legislative, we still have concerns about applying a time limit to processing an amendment that's contemplated here, perhaps more than Jill expressed even for this. I could tell you for many, many reasons, the processing of our comprehensive plan amendment, our other quasi-judicial comprehensive plan amendments can take multiple years going back and forth just to work through the issues that get raised during the process. So we would
So you
remain
know,
concerned about applying a time limit to it legislate, what, you know, regardless of whether it would be considered legislative or quasi judicial.
sure, sure.
Notwithstanding, we recognize the concern and the need to have something in rule to require forward action in good faith, just not a time limit.
Mm-hmm. Yeah, thank you. I think that forward action in good faith is really important. Um, um, and yet these are complicated. So, Shauna, thank you. We do have, don't see any other hands up on this, and I know one of the main topics for this meeting has always been to discuss the urban growth boundary amendment process and particularly clean up what we had in the adopted rules around metros UGB expansions. We'll want to get to that. I want to turn it over to Amanda here soon to walk us over the whole rule and the impact statements. Gordon and I can take up, but we did have a poll prepared. Not to say that a poll is the right tool here, but just to maybe get a sense of the group. Actually, just go back. Yeah, go ahead and hang on that one, Jess. The poll is so that we hear from it, RAC members who are here. So please, if you're a RAC member, so Glenn and Katie, you need to decide who'd be voting here. But the question is kind of from our last meeting, should we establish timeline? We've heard from two counties that say no. But go ahead and I would say, go ahead and vote if you're a RAC member. Hopefully that poll is popping up on your screen and it says, do RAC members recommend a timeline for decisions on legislative amendments? Yes, no, not enough information, or other. And so we're getting some votes in. The no's are winning, but if you're a yes, don't feel bad. Go ahead and still vote. Folks wanting some more time. Commissioner Thompson, does everybody see the poll results as they're coming in, or is it just me? You see it? Yeah. Okay. Yeah. Great. We don't see it, do we?
I don't see it.
You don't see it. Okay. Maybe Commissioner's a co-host. Okay. So it's going to be a surprise. I'll tell you, the no's are leading. There's a couple not enough informations. And then I think it does allow, if Jess has in there, if you chose not enough information or other, it says, I think there's a place you could put in some words. But the ways of Zoom is mostly mysterious to me.
Yeah, if you chose non information or other reason, you should be able to put in a few words about why. And if you're having trouble with that, send me an email and we'll make sure we keep an eye on that. Okay?
Thanks, Jess. Perfect. We do have 13 folks voting that.
I think it is right.
Does anyone else want to get in there? It looks like so. Jess, if you go ahead and end the poll, I think it does show for everybody, but it's no is 10, not enough information is 3, and there's no yeses at this time.
And
do folks see the results now? Yeah, Ellen. Yeah, thanks. So that's how it looks at the moment. So I know it's sort of like what to do if a local government just doesn't continue to process the application. So I would say they would be hearing from DLCD on what's up and what can we do to help move it along qualitatively, but I don't know that there's any other sort of enforcement we can do unless it becomes sort of I'm not even sure if we could do a pattern or practice, but so right now it's looking like we'll leave it without a timeline in the draft rule that we published September 1st, but that would still be subject to public, comment and continued consultation. Does anyone who said not enough information just want to kind of put voice to what they are curious about or would like more information on? There are three folks. I don't know who they are, which is okay. Okay, not hearing. That's fair. I never have enough information, but sometimes we just have to go with the information we have, unfortunately. So, okay, so I think
I mean,
that's plenty for
I
now.
can
Go ahead.
speak. I mean, I was one not enough information because part of it is I want to make sure that a local government does the due process and processes it and just says, no, we don't have time, and it doesn't sit there for 5 years. But I don't know enough about the pros and the cons, right? Like, do we want it open-ended enough so there's enough quality consultation that can go back and forth and the information gathering and right. So you don't want to limit it by putting some type of duration that impedes the process. So I just don't feel like, in my mind, it's like, I'm okay with like a many years out, but does that do anything? But so I wasn't quite ready to answer yes or no. So I'm just owning up that I'm the not enough because I'm still on the pros and cons of both sides. But I really fear that I don't want something just to sit there and there's not staff time or there's not people feeling that they have the ability or understand the process and it doesn't go anywhere. And like you said, if there's no ramifications or process other than a hey from DLCD, we should really look into this. Is there a way to encourage that these applications are processed? So is it a date? Is it a date? Is it something? I don't have that answer, but I'm just trying to wrap my mind around how can we encourage that to happen?
Right. Great. And Gordon, I think that's for us to consider. Is there anything that DLCD can do to help um with it, it's a hypothetical right now, but like if a process got stalled and there was a need for some of Gordon Howard's grant funds, would that help? Or which I'm always trying to raid, or, some other dispute resolution forum. We do have there's a small uh, pot of money that sits every biennium with Portland State University for like if there's some way we can bring some support or help, we could do that qualitatively, but I'm not sure there's any other kind of enforcement ways we can do. But we'll go and let's talk about that to get things unstuck. And also local governments just get busy also too from all the other rules that DLCD and the legislature requires. So local governments do have a lot to do on any given day. Ms. Adams, please, Shauna. And Shauna, if you could speak slowly, your audio in your room makes it a little bit hard to hear. So if you could just speak slowly.
Thank you, apologies. I just wanted to note that with the information Mr. Honeycutt provided, that the poll question maybe could be modified a little bit to be reflective of what the opinion would be, regardless of whether it's considered legislative or quasi-judicial, assuming that there's no timelines that would apply as we believe.
Hopefully folks answered with that in mind, like on these types of projects, should there be a timeline, So I'm hoping that's how people answered, if regardless of how it comes in, even if it came in quasi judicial, but because it's a comp plan, it wouldn't have a timeline. Should there be a timeline? And I'm not sure we would even have the authority to set one in that case, but very fair. Gordon, please.
Yeah, I just wanted to confirm. Apparently most people already knew that quasi-judicial applications that are comp plan amendments don't have a timeline except me, and so I apologize for that. I found the reference to that, and Jill and Dave are right, and Ed as well. So there are some other issues with it being a quasi-judicial application having to do with the bound to come to a decision, the ex parte contact rules and the public information aspect. But the timeline is not a problem with quasi-judicial
Can I jump
comp plan amendments. And Amanda wants to add something.
jump into at least, well, for quasi judicial reviews, we have the example of our aggregate rule that does set a timeline. That's a quasi judicial review that results in a comp plan amendment.
But that's the exception.
Right. Thanks, everybody. Okay. Amanda, are you let's set this aside for now. I think we've had good guidance. Like, let's leave the timeline put establishing a timeline aside. I don't think we'll be publishing one in the Secretary of State notice September 1st, but again, still subject to consultation and public comment after that time. That kicks off the kind of the formal public comment period, if you will, on September 1, if our timeline, if this timeline holds. Jill, one last thought before we turn to Amanda, please.
Well, I'm wondering if the timeline isn't even like premature just because this is a new process and you don't even know like what barrier may actually come up. And
Right.
so I'm wondering if you just don't kind of like put that on hold until a later time.
Good point. Good point. Yeah, and Commissioner Thompson is sort of for you, sort of the things to watch, and we're noticing it too, you know. So if it were to come back to commission, or if there's just a need, you know, a need in a few years to revisit, we could take that up then to Jill's point. Like let's start and see how it goes. Thank you. Good. Okay. Good. Okay, Amanda, if you're ready, I'm sorry you don't have your notes there, but I know you're still gonna do amazing.
Right. I don't have my notes, but I think I'm going to go over what are the largest issues that we addressed in these amendments. And then for those of you who looked through the track change version of the rule, if you see something you have a question about, ask and I can say what's going on there. So one of the big things that we recognized is that we did not in the rule distinguish that Metro has kind of a unique role when it comes to UGB amendments, right? So the Portland metro area has one urban growth boundary. The amendment to change that urban growth boundary is done at Metro, but then all of the work after that is done by the city, and in some small situations, a county that is responsible for applying the urban zoning to the new area within the UGB. So with that in mind, we and when we were looking at that, we also saw that we'd kind of glommed together some things in the rule that made it difficult to be specific, to talk more specifically about urban growth boundaries. We had loaded a lot up front in the section about protection of archaeological sites and then kind of referenced back to that. So what we did was we teased that apart by creating a new section that just speaks to UGB amendments that can say what Metro does in the case of a Metro UGB amendment, and then what cities do, either the Metro city, you know, following the Metro UGB amendment, or other cities that are bringing the UGB amendment themselves and have the responsibility of applying Goal 5 after the UGB amendment when information on a Goal 5 resource site is included in the record of that UGB amendment. So if I walk through these bullets here, so in the rule now, there is a specific direction for how Metro should coordinate with SHPO and how they should manage sensitive information, which we think will be important to pass on to the city, but SHPO will help with understanding what information needs to be passed on to the city and what maybe will be dealt with some other way, which that's their expertise. And then Metro will basically pass, or the rule will pass the compliance with this OAR 660-23-253C to the cities. And like I said, the rule talks about counties in some situations, but that's kind of a unique thing, but we had to make a provision for it. And as a reminder, so the 660-23-02503C is the one that says that if there's information in the record of a UGB amendment that a Goal 5 resource site exists, it doesn't have to be doesn't have to be identified as significant yet, but a Goal 5 category resource site exists in the expansion area, then the city needs to apply Goal 5. Applying Goal 5 means applying the rules that are in Division 23. So if we move on to the UGB amendments generally, then first bullet is that we also added a time window for when tribes needed to be sent information on a UGB amendment. So right now we stuck in 35 days. It could be different if people have opinions about that. And then we also were more clear about applying the goal 5 and the timing of that. The rule previously, we kind of overlapped what the goal 5 rules can do with which Division 23 with what our rules for goal 14, our urbanization goal, so which is Division 24. And it's in Division 24 where information is considered to figure out where the urban growth boundary will expand. And so that happens in Division 24. Division 23 is when the PAPA comes up for adding that already identified area, then that's what our Division 23 speaks to. So in a situation where there's information in the record about a Goal 5 site, then the city needs to apply Goal 5, but we allow the city to do that between the time of the UGB amendment and when they apply urban zoning. So essentially, they have to apply Goal 5 to make sure that new uses won't conflict with a potential site. So they have to evaluate the site, see if it's significant. If it's significant, go through the rest of the Goal 5 process steps to come up with appropriate protections. And that needs to be done before new uses are allowed by the application of urban zoning in that new area. So yeah, so I covered the UGB side of this slide. So Nicholas, what's your question?
I think I understood what you said, but so I'm sure is what you're saying, that for that time period between when something is now in the urban growth boundary, but before it has been annexed or otherwise city zoning laws are applied, the city is still responsible for carrying out the rules that we're writing right now.
Yes, and mostly actually they're responsible for carrying out rules that already are there, because we point to the standard Goal 5 process for what it means to apply Goal 5, but we have some additional direction when it comes to these landscape features of cultural significance. And I will point out that the rule, now our rule, so this cultural areas rule raises this or emphasizes this for the landscape features, because when you apply Goal 5 for the archaeological sites, there's all applying Goal 5 is the notice and all of that. There's no amendment to the comprehensive plan necessary to add a site to an inventory and develop local protection measures for significant sites.
I just want to, this is getting outside my area of expertise, but I just want to raise it as a potential concern and make sure you all greater minds have thought through this. If something is within the UGB, but it's not within the incorporated city, and that it's not within an urban services boundary, the city's not used to thinking and applying those rules there. I mean, because we don't apply the zoning. So what would trigger the city to even know to comply? I mean, they know at some point we can annex that land, but we haven't done it yet,
Well, it might be because City of Portland hasn't, you're already surrounded by a UGB, so you haven't had to, City of Portland hasn't had to do that step possibly since Division 23 was adopted in 1996. I don't know that for sure, but there are process steps involved and required, and we expect if it's a non-metro city, we expect the city to commit to doing that work within the ordinance that adopts the UGB amendment.
Okay.
And then if it's in a metro city, they basically designate the responsibility for doing the urban zoning to the city, and then the cities carry out those tasks.
Thank you.
Just a tiny follow-up, and Katie and Glenn are here, and sort of at Metro and very familiar with Metro's UGB expansion processes, but recently Metro the chief operating officer has conditioned actions associated with the Metro UGB amendment, and then it's therefore the receiving city or jurisdiction to then carry forth those conditions with the expansion within Metro. So that's kind of a known process. Thanks, Nick. Dave, and then Katie, please.
Thanks, Kirsten. Here's what I don't understand. You have a city or metro doing a boundary expansion based on a demonstration of need, and the amount of land that they bring into the boundary is designed to meet that need. And so there's some type of capacity analysis performed based on the carrying capacity for the lands that they bring into the boundary. After all that work is done, we have acknowledgement by the department, and let's say we have no appeal, so that's the final boundary determination. Now the cities are going to go in and do potentially a cultural resource, a significant cultural resource analysis under Goal 5. And if they do that, and if they decide that there are some protection measures that they want to enact as a result of that, and those protection measures have a significant impact on the number of units that are going to be produced on that land that was just brought in the boundary, what the heck are we supposed to do at that point? That seems like a difficult proposition to put both the city and the property owners who have advocated to bring that land into the boundary, and the builders that are going to rely on that land to meet the housing needs of the jurisdiction.
Right, Dave, thank you. If I could take it up first, then Gordon, you might want to weigh in here. Certainly. So I just want to back up to remember the guiding principles of this rulemaking. One of them is that we're mindful of Governor Kotek's priority for housing supply. So very front of mind here that's an urgent crisis for Oregonians. We hopefully in our lifetimes we can see all Oregonians housed. So very, very committed to that. Very simply, from a generalist planner perspective here, the local government would obviously still retain that need and would need to find other areas or would be expected to, and would be supported to find replacement acreage for those dwelling units. Hopefully, Dave, this is sort of part A and there's a part B. Hopefully there would be no surprise to the developers and the property owners that an issue had been raised at the time of expansion, that there was some issues to be resolved. So that could be a process to kick off kind of that inquiry. So the level of surprise diminishes. Concurrently, Dave, over in the Oregon Housing Needs Analysis rule sides and the COW TAC that I think possibly you're tracking, the Capacity and Urbanization TAC, we are looking at whether, and there's Director Radford helped us send out a letter on our agency letterhead from Director Bateman to chairs of tribes, so seeking consultation on whether or not in that study area process and then alternatives analysis process, if tribes wouldn't rather be contacted then far upstream than what you're describing is basically at the end of the process. That's not the time and place to have the best planning work done when folks have already, built in expectations about bringing that land in. So hoping to move upstream with a notice in the conversations to diminish any disruption at the time of UGB expansion. I'm not sure, Dave, if you want to comment on that before we move over to Katie and Glenn.
Well, just a brief follow-up. That makes all the sense in the world. If you're going to have these determinations made, they need to be made at the time that the jurisdiction is determining how much land and where the boundary is going to expand, not after all that work has been done.
Right. Thank you. I appreciate that. It's our thinking as well. Please,
Katie,
go
I
ahead.
want to
Yep, Amanda.
say, so Dave, the conundrum that you're raising for cultural areas is the same one we have for wetlands right now. So during the alternatives analysis, you might know there are wetlands, but you don't know which ones are significant wetlands that are required to be protected by the local government, or at least, apply an EC analysis applied to determine whether or what protections will be applied. So we have the same conundrum there. And we don't know. I guess maybe I'm being optimistic that there will be adjustments that could be made to allow for the needed development and also avoid cultural landscape features. particularly in areas that are close to urban growth boundaries. And I guess, well, I'll just leave it at that. So we don't know right now how much impact identification of a significant cultural landscape feature will have on new development within a newly added UGB area. Just like we don't exactly know about wetlands either, because you can have uh, my brain's not working. What's the word? So essentially you have the same number of units, but you shape them. You make smaller lots and you keep some spaces open space. You build up rather than out, things like that. So we do
We're looking
have
for a clustering development, Amanda.
yeah. So there are mechanisms that could well result in not having a significant impact on the housing and other development that's needed while still being cognizant of an important cultural landscape feature and doing what is possible to avoid impacts to it. Oh, and then last thing I'll say is that if a city does end up at losing capacity, then that capacity is addressed at the next UGB expansion effort. And that's described in the Goal 5 set of rules right now.
So a small little aside there on, and how this is kindred to the wetlands. So thank you. We're also taking up wetlands rulemaking though in the next biennium to try and address that. So as the land use system is evolving, we're trying to clear the way for development once a UGB expansion has been determined so that it's quick to then provide the supply for which it was intended. Katie, please.
Thanks. My comment, really quick, I think Glenn has others to share, was just around the timing piece for when tribes are informed before the first hearing. If other folks on the RAC were comfortable with making that 45 days, I think just based on how our internal processes are administered, that would ensure that there was at least 30 days of genuine time for tribes to review and respond to that.
Thank you. Amanda, did you and Brett and Laura who are on the call, Nick's giving us a thumbs up, but did you have any magic moment for 35 days? I know that's now our Papa Notice time, but any objection to lengthening that out?
We have not had much discussion. We just kind of put that in as a placeholder.
Thanks, Katie. Thanks. So I'll try and bump that up. Appreciate the comment. Glenn, please.
Yeah, I'll be quick. I really appreciate Dave's comment and question, and I just want to elevate the response that Deputy Director Green and Amanda gave and concur with that response that there's already this kind of tension that when the UGB is expanded, Metro's UGB is expanded, we don't know at that point exactly how much acreage would truly be buildable. It's a dynamic that gets sorted out in the subsequent comprehensive planning stage, including through consideration of Title 13 designated areas, et cetera. There is generally a condition of approval in the Metro UGB ordinance that requires the jurisdiction responsible for doing the planning of the new urban area to plan for a certain number of dwelling units in that area. And they're going to have to also plan for protection of other spaces, be they habitat spaces, be they cultural resources. And so this is just part of the puzzle in comprehensive planning, is that the planning jurisdiction will be responsible for thinking through sometimes competing interests. And that's a dynamic that they're used to. But it's certainly the case that they might discover through comprehensive planning that areas that they had intended to urbanize are not necessarily urbanizable for various reasons, and that in order to meet some minimum density requirement that is set based on a projection of growth, that they're going to have to increase density elsewhere, for example. So just wanted to echo that comment from others. Thank you.
And thanks. Thank you. Well said. Amanda, is there anything else you want? Dave, please, yeah, before we turn to the fiscals, please go ahead.
Last thing I'll say, and then I'll shut up.
No, we're here to hear from you. Thank you.
And I appreciate what Glenn said. The only distinction that I think we can make for this particular set of rules is the definition of potentially significant cultural landscape feature is so broad that it could potentially have a overwhelming impact on the capacity of the lens that just got brought into the boundary. If we had a narrower, tighter definition, if it was easier to understand what a potentially significant cultural landscape feature was, then there may be some, the development community, we'd have at least a little bit of comfort. But that definition is, at least in our opinion, is overly broad. Number one, and the impact is potentially significant.
Right. Thank you, Dave. You know as well, we've been wrestling with that for years, and acknowledge what you're saying, that it is broad, hence the reason to want to go upstream, to investigate that, earlier in the study area and the alternatives analysis phase. So it's walking forward carefully together on this. Thank you. Hopefully together. Amanda, anything else on this slide before we turn to the fiscal impact statement?
So we didn't get to the other technical fixes and
real quick, Glenn, I would just wonder, Glenn had his quick hand up and then down. Glenn, did you have anything else on the UGB or Metro's role?
I did have one quick comment. I don't want to get the conversation off track, but wanted to flag that in 7A, just that term, a local government shall notify tribes, et cetera, et cetera. We just were hoping that it could be clear that in the case of a Metro UGB amendment, it would be Metro rather than, for example, a city or a county that sends that notice. For reasons, we wouldn't necessarily want a city that's making a proposal to Metro to be responsible for sending the notice. Metro would take on that responsibility. Thank you.
Yeah, we have that comment, and we will make that change in the next round of amend or fixes to the rule.
You guys rock. Thank you.
And if we don't get it right, Glenn, please stay with us. Thank you. Okay. Amanda, please, other technical.
Yeah. So for those of you who have read through the rule, if you have questions of some of the edits, I'm only going to just touch on a couple here really quickly. And I don't know, Kirsten, you can decide if we have time to do anything else, but super easy one, the list of applications requiring notice to tribes. And this is for a PAPA application that somebody comes in to, do some kind of development. The legislature just removed, and this is where I don't have my notes, but it was some kind of, not limited land use decision, but some other kind of decision. They removed one kind of decision, and so we removed it from the rule. And then just to make everything simpler, I think I added a subsection down at the bottom that just explains what it means to notice tribes, the bit about working with LCIS, getting the tribes that have a cultural connection to the jurisdiction. Jurisdictions will get that list. They have to send notice to tribes that are on the list that they received from LCIS. So now that has its own subsection, and it's referenced. We have references to that new subsection throughout in the rule when we talk about notice. And then treatment of responses to notice, basically with the new UGB section, we were able to separate out how responses were handled for UGB amendments versus other PAPAs that local government is processing. And then there's a dozen or more other little changes. And like I said, if someone has a question right now, I can address it. Otherwise, we can send me, we can talk about outside the meeting or whatever, Kirsten, you think we should do there.
Sure. We had this idea where Amanda would go over all the changes and then, and the fiscal, and then we'd have this big block of time to talk about the changes, but we've been doing it kind of as we go. So do we just want to, I'm tempted to kind of stay with the rule right now, as long as we can get to the fiscal by about 2:20, 2:30 this afternoon, and because I'd love to, maybe we just stay with the rule and then turn to fiscal. So we'll go with what's natural. I'd love to invite, I see Carrie, your hand up, thank you. And I'd love to invite any of the representatives from the Confederate Tribes of Warm Springs to put some voice to their letter if they wished. And then we'll turn to the fiscal in 20 or 30 minutes. If that works for folks. Carrie, please.
Thanks. Hopefully mine's a quick question, but I don't quite speak all the land use planning lingo. So under what number are we in? So I'm talking about the technical fixes here where you're notifying tribes under something B. So you're notifying tribes under 197, 195, 197, 797, and some Oregon laws. So Amanda, you just said you dropped something off. So I'm trying to understand which land use decisions tribes will be notified for and which ones maybe we will not be notified for. If you could just clarify that for me, and that would be great.
Yes, and sorry, I made a face while you were talking, but it was because of something I did on the computer, not because of what you were saying. So we're keeping with the same concept that was in the rule, that essentially the tribes will get noticed of plan amendments, applications for plan amendments that will have ground disturbing activity. That's for the archaeological protection, and then there's a parallel statement for rural lands under the potentially significant landscape features. So we're keeping the same structure there, but we had listed out the types of decisions that were that required a public process. And this is in, you had it right, it's 5B, is that right? 5B, yes. And the legislature in the last session removed its expedited land divisions from a requirement for a public process. Is that the right way to say it, Gordon?
For public notice.
For public notice,
Yeah.
okay. So because they removed it from the requirement for public notice, we removed it from our list here.
Can you clarify for me what an expedited land revision might look like? One might argue that tribes are not part of the public process. So I'm just trying to understand if it's something we'd still be interested in.
Yeah, this is Gordon Howard again. Expedited land divisions occur only in urban areas, in areas zoned for residential use where the land is proposed to be developed with subdivision lots that comply with the existing zoning. And I believe there's also a requirement that the city doesn't have any existing Goal 5 resources identified in their comprehensive plan for the area. So yeah, and the reason it be removed is because nobody would be getting notice, tribes or anyone else, of such applications. And I mean, I hesitate to be to completely categorize them, but I think that the thought is that a tribal government would have little or no interest in almost all, if not all, of these types of applications.
Understood. Thanks, Gordon. I apologize for my ignorance. I'm just trying to make sure I understand where the rule's applying and what's going to happen as we move forward. So I appreciate you walking me through that. Thank you.
Sure.
There's no one person in Oregon that is that knows everything about Oregon land use. So please, no apologies needed. And you already, from being with us for 4 years, you've already gotten an honorary degree. So thank you. We all are learning all the time. So thank you. Please, questions are always welcome. I do have a copy of the kind of the rule up and of the track changes version. I think I do. I was going to share it and invite Confederate Tribes of Warm Springs to just make any comments they wish. I know they have, anyway, Confederate Tribes of Warm Springs, would any of you like to make any comments about the letter that we included in the packet? You're welcome to. Just at this time, Ellen had to take a call. So I probably called on her at just the wrong time. From our discussion, I was able to touch base with Ellen a little bit before the meeting yesterday. And so I know that Mr. Scumpin and also Mr. Austin Smith Jr. are on the call as well. I believe that, there's a number of concerns that they laid out in their letter, and I don't want to try to kind of recap them all. So just watching to see if Ellen becomes available. Otherwise, we can just simply turn to the fiscal impact statement and come back to this. But the
Um,
go ahead,
Kirsten,
Austin. Yeah, thanks.
yeah. Sorry about that. I was messing with my mic. You guys hear me? Okay. Sounds like.
Yep, thanks.
So yeah. Just to touch back on what the Confederate Tribes of Warm Springs, and I'm sure there's other tribes that agree with the quasi judicial process is standalone, not appropriate for the tribe's resources as of course, limitations are being considered. Um, you know, our discussion about the rules around quasi-judicial would be different for these type of decisions. And also the pre-application consultation is very critical, especially for tribes. We're constantly getting the rigor mortis of notifications. And each tribe are different. Some tribes have their TIPO, which for ours, our TIPO's responsibilities are within the boundaries of the reservation and other trust lands, while other organizations have it span it out wide area. And for us, the cultural resource director and the cultural resources committees are more or less responsible for receiving those notifications. And so then that consultation step is always, we're getting flooded with a lot of these applications, and as they're filed, and it's usually typically it's timely, it's at the last moment that we're allowed to intervene or to give comment. And so perhaps allowing local jurisdictions the opportunity to work with tribes. I just reading back on some of suggestions that we've had in the past with is developing the intergovernmental agreements. Those have been very helpful in the past, especially given the provisions of this rule. I also have Larry Scrumpin, who's our TIPO in here listening in. I don't know if I've touched on everything, Larry. I know Ellen had a lot more to say, but of course she's on a call right now. So, is that what you're looking for, Kristen?
Yeah.
Yeah. Okay.
Yes, exactly. Thank you. Larry, anything else you want to chime in? You're good?
I think you got it all. Okay. Yeah. Sounds
Cool.
No, sounds we're good. Yeah.
Cool. I might just share the one things I touched on with Ellen, not to say it's sufficient, but there is this I'll try and share my screen. If I go slow to go fast here, it might just work. I'm gonna stop, Jess, I'll stop your PowerPoint here. Rudely just grab the screen share there. So there is this piece, and that's one of the reasons I was looking forward to talking with Ellen, and we were able to connect tomorrow morning. Austin, sorry that didn't work for your busy calendar. There's the I think it's this, no, we get out of urban growth boundaries. We just talked about that quite a bit. And consideration of potentially significant landscape features. It's this new 9. So it used to be 8, I believe. And Amanda, please correct me, but this is that a local government may adopt procedures for consulting with tribes. So this is trying to get at that IGA or MOU that I hope you're speaking to, Austin, which is a local government may adopt procedures for consulting with tribes on the decisions described in 5 and 8. So that designation of a culturally specific landscape feature that could impact cultural areas that are valued to one or more tribes. So the idea here is to allow for a local government to define a special program. Amanda, have I got that? Yeah, Amanda, correct me because I'm not sure I'm in the right exact section.
You are. This section though was created to provide a different strategy for communicating with tribes. So it replaces notice requirements. It's not about a different way of designating significant sites.
So this is, I should be in optional and additional local protection strategies, actually. So I think I should be in the next, I think I meant,
are.
yeah, I think I meant to be in the, I'm looking, sorry, in my hard copy here, I have the clean version, which is, it's now 9.
Yes.
And so I think I mean to be up here.
So that
Here's
is
what,
it.
that's what I meant, Austin. So it's this, it was 8, now it's 9, the optional and additional local protection strategies. Yeah.
But it's still, Kirsten,
On
that
notice.
that it's more about the notice side of things, the communication side of things. It's not a different way of designating a significant site.
Got you. Thank you.
So
Thank you.
essentially, if goal 5 is the reason is one of is a reason allowed through our land use laws to curb development that is otherwise allowed, right? So you have to go through the goal 5 rule to do that. You can't really do it separately unless everybody's all copacetic, right? If all the property owners and everybody's all on board, then you can do that. But as far as zoning something, well, I don't know, maybe even if the property owner's okay to change the zoning, maybe even happens, and who knows what happens in the future. But essentially this part was about the communication side of things.
Too. And so Austin and Larry, I think that you're to the part of receiving so many notices. We'd love to stay in consultation with you about this. I know that when we were out in October, we talked about, just floated the ideas of, would there possibly be a subset of geographic area in your ancestral lands that would be of interest to the Confederate Tribes of Warm Springs, such that you're not receiving all the notices from a multi-county area. So would love to continue to explore that with you all and with the associated local government. So I think that does lay in here in now 9, which would be, as Amanda's clarifying, would be on the how much notice you would receive. So thank you. Okay.
And how you would receive the notice, right? So the examples here, the big example is City of Salem that has a program with the Grand Ron and
Siletz and Warm Spring, or Siletz and possibly, sorry, it might be Warm Springs or Umatilla, forgive me, but there's several tribes.
yeah, and they identify issues early on and they communicate, and that works really well for them. So the idea is that this rule allows for that kind of collaboration, and then if a tribe in a city develops that, then you don't have to also do all the stuff listed in the rule.
And that City of Salem, I don't think we have Kimberly on, which is crushing because she's done so much work, Kimberly Fitzgerald, but I just wanted to clarify the City of Salem's process with several tribes. And I think Austin, is it Warm Springs as well as Grand Ron? And so that's
that's what I understand.
Yeah, thank you. Yeah, thank you. So that's certainly one concern, and very very understandable. Austin, you probably have seen my multiple emails to see if we can come out and visit with your council in August. I've been trying to reach Bobby, but he's a very busy man to try and get that scheduled, but would love to stay in consultation with you on what how to have this, at least even the notice requirement section be more fitting for Warm Springs. Sorry. Yeah.
Yeah, we have a new change of leadership, so we'll be getting all that information out to everyone here soon. New chairman, new treasurer, new vice chair, all of that. So.
Oh my gosh, great. It's big, and congratulations on those elections, but I know creates a lot of change. The other part that Ellen did bring to our attention that I might just flag here for everyone's awareness is up here in our old friend 4C rather, which is a local government shall accept an application from an Oregon-based government for the culturally specific cultural landscape feature. And we are getting some folks entering the waiting room, which is always makes me nervous because of our experiences last time. So folks who have entered the waiting room, if you don't mind renaming yourself before we admit everybody, I'd appreciate it. We're just still a little skittish from the experience of our last meeting. So if folks could, whoever's entering the waiting room, there's now 3 people. If you could go ahead and rename yourself before you come in. Also, I would ask that would apply to Ann Rogers and also Lara, Lara. If you could rename yourself with your full first and last name, I'd appreciate it. So, and Kasari, if you could watch that folks entering the waiting room would rename themselves appropriately before you admit them, I'd be grateful. So up here in 4C, a local government shall accept an application from an Oregon-based tribe or government here to determine if a landscape feature is significant. Ellen and I were discussing what if there, how, and then what currently in the rules, what's required is the local government would then notice the tribes with an interest in the area that the list would be held at LCIS, and we're grateful for that. So local governments on the phone, we're know you're sensitive to like, okay, what if the tribes don't agree on the feature and the resource? We we'd like to give a little bit more thought to this and encourage tribes to consider, what might happen if there's conflicting or multiple, sorry, I won't assume conflict, but multiple tribes' interest in any given area or feature due to historical use, treaty rights, and that there might be a time period that we want to build in here that a local government would send that notice and then wait to hear if there's other tribes, other nations with an interest in the area, to be able to then sort of plan accordingly. So I'm not sure if Ellen has come back in to be able to discuss this piece or if she's still on her call. It looks like she might still be away on her call. But that was the idea here, is to do a little bit more process here around centering the resource. I know as always Bree's advice, he couldn't make it here today, but thinking about okay, all right. We're gonna have to exit everybody. Sorry, we've muted all while we exit some people from the meeting. Sorry about that. Just trying to hold together here while we exit people who we aren't sure who they are. And I'm sorry, we're going to exit you as well. So please email me if you can to let me know who you are. Just giving it a few more minutes while we exit folks.
Kirsten, can we take a 5-minute break?
Sure, folks, let's take a 5-minute break and we'll come back after we've exited folks who we don't know who you are. Thank you.
Thanks.
Please join us at 2:25. So right now, we're just providing, I know we're still on break here, but we're providing folks in the waiting room. We're locking the meeting and we are, invite people to join on YouTube. So we'll put that in the chat here. We always stream these on YouTube as well. So anyone, apologize if we unceremoniously booted you from the meeting. Please join us on YouTube. And be in touch with us via email or phone. Thanks. We'll come back together at 2:25.
Thank you all for your patience. If you wouldn't mind attempting to unmute and turn on your video, you should have all of those capabilities back. If I see a few of you do that, then I'll feel confident that I've reinstated okay.
Thank you, everybody. Okay. I think I might.
Situational awareness, I would say. Thank you.
Yeah, Kasaria, quick work. Thank you so much. It's unnerving, but we'll carry on. So thank you, Kasaria. Welcome back, everybody. A short break there while we remove some unidentified objects from our meeting. So please, human or otherwise. So please go ahead and come on back in, come on camera if we can see your beautiful faces. If not, we understand. We've got some on here. So I know that there's someone on the other end. We were talking a little bit about Confederate Tribes of Warm Springs letter in the packet, and this piece here, which is 4C, which is the local government accepting an application and thinking about the notification to tribes with an interest in the area, ancestral interest. And if that, then providing a comment opportunity, a bit of another window of comment opportunity for those tribes to be known, so that the local government can see that there is more than one tribe with an interest in the area, before they move forward. So looking to do possibly a little bit more work on 4C here, just again in response to Confederated Tribes of Warm Springs letter, but also just knowing too that due to the honestly traumatic history in Oregon of forced relocation and displacement, that that there's several tribes, many tribes that could have an interest in a given geographic area. So providing that notice requirement and then allowing tribal representatives to weigh in to express their interest in any given area before the local government proceeds with their comprehensive plan amendment. Couple hands raised. I need to scroll up and see the who's are. So Nick, could I go to the DLCD staff because Amanda's often getting me back on track here. So if it's okay, I'll take the DLCD room first. Thank you.
Thanks, Kirsten. And you are on track. I realize that I wasn't thinking clearly enough about this when we spoke this morning, I think, about thinking that because an application would come into a local government, it was a plan amendment, so the tribes who had identified interest in that area would get notice. But these kind of applications aren't about ground disturbance. So they would not. So we would have to build in a separate notice requirement.
Great. Thank you. Thank you. Thank you. So honestly, I think we just know that. Oh, Nick, please go ahead before we move
Well,
away.
I think you mostly just answered my question. Just so the what you're raising now to the group is you're asking us what staff is considering to add an additional notification requirement
Mhm.
for when an application is received by local jurisdictions to notify tribes. That's what you're, and so,
Right.
okay. Yeah.
Right.
Okay.
And I know that with this group or our last group, before the rulemaking was adopted in December, it discussed notifying other tribes with interest in an area, and we just may not have caught it. So we want to just comb through and make sure we have that, and then adding a waiting period to see if other tribes would like to express interest in that resource.
The only, I guess, and yeah, I'm certainly open to that. It's, my first take is that would be a great thing, but I'm not sure about when you say adding in a period of time, because if I understand where we stand on the timing,
Yes.
there is no timeline because it's a comp plan amendment. It's not subject to 120 day, and if it's legislative, there isn't. I guess the legislative one is bound to reach a decision, so there's theoretically a time limit, even though if it's unspecified. So I'm just raising that, like what the time limit or the timeline would be for that notice. It's just open question as you're thinking about crafting that rule.
Right. Yep. And this is new, so we haven't
Yeah.
kind of contemplated what that period would be. So certainly open to folks' ideas there. And this is why it may be worthwhile to just like I said, extend the consultation and comment period on this rulemaking to allow for tribal representatives to talk to each other on that matter and to inform us. With September 1 coming pretty soon, we might just put a date in there, a time period rather, and just say it's a 60-day notice or some other period. But we welcome guidance on that point.
Well, I guess that's my question. Like, I don't know what a 60-day notice, before the first evidentiary hearing, before a decision is made, like what is yeah.
Right, what's it pinned to? It'd be after the application was received. So
After it's received, and before what though? That's
a very good question, but I think it's to allow a period of time for other tribes to express interest. So it would be so say like the ground disturbing activities within 7 days of receiving the permit, the or the application in this case under 4C. So
Yeah.
with if it's City of Portland, if we can run with your jurisdiction, if the City of Portland receives an application for a culture designation of a landscape feature of cultural significance, it would say, okay, LCI, I have this list from LCIS. I'm going to let these, 5 tribes know, and then wait for 60 days to see if anyone weighs in with an interest, and then the local government would know at least who would like to be engaged in the subsequent proceedings. That's the idea.
Yeah.
Yes. Thank you,
Seems reasonable.
Shauna. Please.
I just want to chime in since you talked about just now 5BA in addition to 4C. I do favor adding at least under 4C additional notification. I think the most robust notification would be great. Personally, I favor, and I think it works a lot better for our local government if the notification requirements are tied to a before something occurs rather than after application or right. In the example, you said notify tribes within 7 days of receiving an application. That's not something that this RAC, I think, is looking at, but that is something in the rule that gives me pause because we haven't always figured out what somebody's applying for, or even, we don't even know we have the application or assessed whether it's ground disturbing by 7 days usually. So it's a little bit more complicated. And I could say the same thing would be true of a notification in 4C if it's tied to the date of submittal. So maybe if there's not a mandatory completeness review process, but maybe if it's tied to before something occurring, that would be.
Right. That is challenging because of the lack of timeline. We'll continue to think, Shauna, thank you for that perspective. And if we don't get this all patted down quite correctly before SOS notice, let's just remember that RAC members, please stay with us to and through the Secretary of State notice, the public hearing in September, and then another RAC meeting following that public hearing, whether or not we extend the consultation and comment period past October 5th. I'm inclined to extend. Our director is supportive, so looking probably to extend maybe the consultation and comment period to the end of October, say, so that we can get the packet ready for a December 4th and 5th adoption. So we wouldn't delay that indefinitely, but it does seem like this point could use some more work. And that, Shauna, that whole discussion around notifying tribes within 7 days of receiving a ground disturbing application was subject of a bit of discussion during the previous RAC, because you're right, that was adopted in December. The idea is so that tribes could express interest, concern, suggestions within the completeness review period. I'm not sure if that helps or not, but that was the intent there. Ellen, you missed all the drama. I see that you're back. We had an unidentified flying object come in and through our meeting, so we had to take a pause there, but we're back just talking about the notification of tribes. Sorry, go ahead. Ellen, go ahead.
I'm sorry, I just got pulled away. If there's anything I can offer the group, if you have any questions, please just let me know. I'm happy to chime in.
Thank you. We were in Austin and Larry were on too, so no worries. The tribe was so well represented. We were just talking about the 4C and the local government accepting an application, and then by creating a period of time wherein the other interested tribes would be noticed within that geographic area, or all 9 tribes, perhaps within, say, 60 days of receiving the application. So the other interested tribes could comment, say, hey, we care about this resource as well. So the local government would know. Shana was describing that, she was pointing to kind of that 5B, which we're 5A, which goes back to notification of ground disturbing activities, and just acknowledging that local governments sometimes don't 7 days is very fast for them too. So it's all subject to comment. Once we publish on September now, and once we publish the new draft September 1st, it's still all, Shana, so all the material is subject to public comment. You don't have to restrain your comments or your concerns on that point. So we'd welcome it. So that's the idea, Ellen, responding to kind of our discussion. That's kind of our running idea right now, is to allow for notice of either all 9 or the tribes that have articulated to LCIS interest in that geographic area.
Yeah, thank you, Kirsten. I think that's consistent, with Austin's letter, just, making what we're providing space for is consultation where tribes may want it, with the local jurisdiction and among the tribes. So that's really kind of the point of the notice. And if there is, if these really are legislative, procedures without a timeline, after receiving the application may be fine, for that notice. Once you trigger if it's a quasi judicial and you start triggering the timelines, under those quasi judicial, notwithstanding the comp plan, I understand the comp plan, wrinkle there, but anyway, if there are timelines, then that does become very problematic for local jurisdictions to be able to adequately consult, because all of a sudden you're in ex parte concerns, and you really can't do those government to government consultations to really understand and exchange information. And then also the timelines just really are not adequate for that. So that's the big concern I think that Warm Springs would have. Yep.
Thank you. Thank you. Great. I really appreciate the letter, the thinking, the participation, the consultation. Ellen, thank you. Thank you, and Austin. Amanda/Gordon, please.
It's me.
Yeah.
So two thoughts. One, Ellen, you're using the word consultation, which I just want to be clear that as a state agency, we have obligation to consult, government to government consultation. We don't have that same requirement, at least in our law, for local governments to consult with tribes. But the conversation, that's what's important, or consultation with a small c. I just wanted to raise that. And then just a thought, and I'll mention it now just so that the tribal representatives have time to think about it. I wonder if an application requirement for the tribe, well, I mean, it says Oregon-based government. So anybody who's coming in with an application, that there's an application requirement that they have notified the 9 tribes of their application. It might be another way to deal with it outside the time constraints of the local process.
Yeah. Thanks, Ivy. I'm happy to again just provide some thoughts to that. I think to the extent they have local jurisdictions starting to make determinations about culturally significant landscapes, they have to we have to build in an opportunity for them to appropriately consult, whether it's large C, if a governing tribe asks for that, if a tribal council asks for that, then the local jurisdiction should have, in my view, an obligation to meet with that tribal council. I don't know that a tribal council would do that with a local jurisdiction, but at the very least, you would have that small c consultation. Yeah, I mean, I think there are, probably a number of ways to sort of think about how to manage the intertribal consultation obligations, they talk a lot in lots of different forums. And maybe you do have, as part of a complete application, that they've conducted some of that outreach, but I don't have a feeling that yes, you should or shouldn't do it that way, but that is an option I think that could be considered.
Before we completely workshop this right now, because I know it'll take some more time, we better touch on the impact statements. I'm sorry we lost a few minutes there. We may have to go to a different Zoom function, which is called a webinar, in which case every one of the RAC members will receive a panelist link, but that is one way to make sure our room is more protected. Who knew that we could have an audio disturbance as well as screen? So sorry about the little bit of lost time. Could I please turn to the impact statement? Because I know I heard from one RAC member that they wanted to explore impacts to the tribes a little more thoroughly. Would anyone like to comment on that or any other part of the impact statements? It carried forth from our 2024 rulemaking quite a bit, but I welcome anyone's comments on the impact statements here. Just gonna give it some time, let people flip through their packet. It's our last piece today. Thanks, Jess. Lynn, yeah, please.
Sorry, I'm just passing on from Katie that she got locked out of the Zoom. So she's following along on YouTube, and that would have been her. Katie, are you in yet? Can you hear?
Oh, she might have been iPhone. I'm so sorry. Yeah, we threw her out. I'm sorry.
That's okay.
She'd probably transferred to her phone. Now knowing that that is her, if she is able to rejoin, that would be great.
She might be working on it. Also, I just got a message that she's going to email everybody with any concerns or questions that she might have too.
Sure.
Thanks for your patience with that.
Of course. Well, golly, thank you, everybody.
Kirsten.
Yeah.
Kirsten, that means that I will be unlocking the meeting,
Oh, right. Yes.
but the waiting room is still enabled.
Okay. Yeah. So we can see Katie come in, but if she renames herself in the waiting room, we'll know it's her and she can come on in. I feel like a bouncer at a nightclub, but that sounds more fun than what we're doing here on a Friday afternoon. So I'm going to move right along and just relay what I had heard from Katie in her email. She said she wanted to make sure we had time to discuss this today, which was that the racial equity impact statement did not adequately account for the impact to tribes for these rules, and we agree that should be in there. So I'm happy to work with Katie directly on a draft to make sure that kind of is better captured. So it's in that final page of our racial equity statement. The racial equity statement in Oregon came pretty recently, passed by the legislature. It's ORS 183. It's cited there in our paper. And there was very little guidance in the statute. It was like a half a line sentence on thou shalt include a racial equity impact statements in rulemaking. So we're going with some advice from DOJ on describing the impacts, and we know that tribal nations are both governments and, according to the census, racial and ethnic groups. So we can certainly do better than what we have currently in the impact statement, and recognize that for tribes who wish to participate, that it certainly is, there's no additional funding to take on that expense, and it's certainly regrettable. We wish there were. Glenn, any other comments there from Katie or you guys?
Yeah, thank you. I believe you just answered what I understand is Katie's question. She was raising to me to ask whether there's additional resources for tribes for help processing or responding to all the applications, especially considering the very large areas that they were likely to receive notices from, which you just touched on, I think. Thank you.
Yeah, sorry. This is one of the very thin lines we've been walking on this rulemaking, because it's didn't come with additional funding from the legislature. It's agency initiated, actually. So it's initiated by DLCD. When it's legislatively initiated, we can put a fiscal impact statement on it in that regard, and ask for additional funding for kind of rulemaking processes like this, and or grants to implement, such as there are grants to implement the governor's housing priorities. That local government's doing a lot. Metro's doing a lot to implement the governor's housing priorities on housing, and sometimes there are grant funds that go along with it. We don't have any of that on this, so we've tried to make the rules voluntary for tribes to opt in to receive the notices and or to bring an application. And there's no requirement that cities and counties on the other side go and complete a thorough cultural resource inventory. And we wish we had the millions of dollars that would be and necessary to really do that again. That would have been better done at the initiation of the initial comp plan adoptions in the 70s and 80s. So unfortunately, we're just trying to make progress here, but not create big unfunded mandates. But along with that, we also don't have large resources to help support at this time. Unfortunate. But still trying to make progress, even when there's not sufficient resources. Thanks, everyone. Okay. I think I've burned everybody out on meeting on a Friday afternoon. There's not even any hands up. Is there a next slide, Jess, that we had? It probably says next steps. It says thank you, which is true. Probably even you can bring that the slideshow down, Jess, because there's we're just saying thanks, and I'll turn it over to Commissioner Thompson to bring us home in a moment. The next steps are to continue to clean up the rules associated with the track changes. So thank you everyone for your guidance today. And to publish. So we'd be moving forward to publish September 1st in the Secretary of State Bulletin. As is scheduled right now, we'd have a public hearing on the topic at the September Land Conservation and Development Commission meeting that happens to be in Klamath County. So we hope to be visiting in person with the Klamath tribes at that time, just good timing. But the hearing would likely be on September 25th. Then we'd be moving into either trying to meet quickly with you all again before October 5th or extending that consultation and comment period till the end of October and having our RAC meeting some other time in October. Amanda and Gordon, please. And then final adoption in December. Sorry, final adoption December. I believe the commission meeting is December 4th and 5th, so we'd probably be having the adoption meeting. That would not be a public hearing. That would be on 4th or 5th of December. Sorry, Amanda.
Curious for myself, and so maybe others are as well, since this rule was not filed with Secretary of State for the version that was adopted by LCDC, when we post it this time for notice, will it be basically clean with how it looks now, or are we posting it with track changes from what LCDC approved but was never filed with Secretary of State?
It's a question for Xeri, but I think it would be the whole thing would show up as track changes again because it was never completely closed before, right? So the whole thing would be new. Gordon or Xeri could correct me there, but
if we're going to include the language that was also adopted in December, it will all appear as new language.
it'll all be track changes. The entire rule will be tracked again. Yeah. So we can do a compare versions for this rec. Nick, please, yeah.
Yeah, just to be clear, so this committee is not likely to get another draft before it is officially released as a draft to the whole world, right?
That's right. That's right.
Okay.
That's
So,
right.
so any comments, that we might have on the current draft that we have, we should get to you like pretty much ASAP, right?
That's great. Yes, by the end of July. Actually, thanks, Nick. So yeah, so comments. Why don't we email out the entire rack and also probably put out a gov delivery that would say final comments in writing are welcome by the end of July so that we can incorporate them into the September 1st notice.
That would be helpful, and maybe if you would if you agree, it might be helpful too with that communication to just say what you are working on that isn't in the current draft, like we were just talking about the new notification requirement. I mean, not in detail, but just so we know what to look for, when that next draft. Yeah.
You got it. Yeah. Thank you. Thank you. Good guidance. Okay. With that, I would turn it over to Commissioner Thompson. Please bring us home.
Thank you. This process is fascinating because what we're doing is combing through to see where the snarls are, to anticipate the unanticipated consequences of whatever we're dealing with. One of the things I'd note that in the Clatsop County Comprehensive Plan, we had a section for things that were in motion. So if that's allowable in terms of the requirements for the Secretary of State's, to have in motion the aspects that we're still working on so that we can continue to refine, I hate to use the word perfect, but make it better, to improve it until the very end, and then be prepared to go forward to accept openly the feedback of the consequences in the real world. That's what I think we're looking for, the consequences in the real world that both honor the past, the present, and the future, so that we're balancing culture and property rights appropriately. And I'm so grateful to everyone who participated in all of this. Thank you.
Thanks, Commissioner, and everybody. Will be in touch and look forward to seeing you again soon. Thanks for your years of work on this. Please stay with us. We're getting there. Appreciate it. Good night.
Thank you all.
Again.